The broadcast is now starting. All attendees are in listen-only mode.
Hi, good afternoon, everybody. Thank you for joining us for today's webinar, Understanding the SBA's Affiliation Rules. My name is John Williams. I'm a partner with PilieroMazza's Government Contracts Group, and I am joined today by Kimi Murakami, a counsel in our Business and Corporate Group. A little bit of housekeeping before we get started. If you have any issues hearing us, or if you'd like to ask a question during the course of the webinar, please feel free to submit your comments and questions in the question box. We're going to try to answer as many as we can by the end of the presentation, and we want to make sure everybody can hear us. Also, a very common question I can just answer right off the bat. We will make a copy of the slides as well as the audio available to everybody shortly after the webinar. We're going to email it out, and there will also be a link to it on the resources page of our website at www.PilieroMazza.com. Again, it's going to be the resources tab of our website. So with that, let's talk about where we're going to go today. We are here to talk about the SBA's affiliation rules, and this webinar is the culmination of a series of webinars that we gave over the last several months on the various small business set-aside programs. And in case you missed any of those webinars, they're also available on the resources tab of our website. The reason we saved affiliation for the end is because affiliation impacts small business status, and small business status is the most important eligibility criterion for all of the different small business procurement programs. So if you participate in any of those programs, it's really important that you understand how affiliation can impact small business status, and that's where we're going to start today. And then we'll get into each of the different types of affiliation under the SBA's affiliation rules and some of the exclusions from affiliation in the rules. And then we're going to conclude with giving you some real-world examples and some tips for how you can avoid common affiliation issues. And like I said at the outset, we're going to try to save about 15 minutes at the end of the presentation to answer your questions. So please fire away during the course of the presentation, and we'll get to as many as we can. And we'll follow up with anybody via email afterwards if we don't get to your question today. So why does size matter? Size matters because, like I said, it's the #1 eligibility requirement for all the various set-aside programs. You have to be a small business to participate in these programs. Being a small business as a government contractor also exempts you from certain requirements, such as reporting executive compensation, contractor code of ethics, and cost accounting standards. There's also the new presumed loss rule, and if you haven't heard about this yet, you should try to learn more about it. We did a webinar on that as well. You can find on the resources tab of our website. The presumed loss rule increases the importance of verifying your small business status before you submit a proposal, because there are now increased penalties, and the goal of this rule is to boost prosecutions of misrepresentations of size or status in small business contracting. So you just need to be aware there's an increased focus on ensuring that companies that represent themselves as small are truly small. An affiliation impacts small business status because of how it adds your affiliate's revenue to yours in determining whether you're small. The first bullet here shows you how your size is determined in a vacuum. The SBA would look at either your annual receipts over the 3 most recently completed fiscal years, or for certain industries that have an employee-based size standard, the SBA would look at your average number of employees over the last 12 months for each pay period. When you have an affiliate, the SBA is going to add the revenues or the employees from your affiliates to yours. So you might be a small business on your own, based on your own tax returns, for example, but if you have affiliates, the combination of revenues from your company as well as your affiliates might cause you to be other than small. So it might cause you to lose your small business status. That's why it's so critical. So what is affiliation? Let me talk a little bit about some basics, and then I'll turn it over to Kimi to start drilling down on the specific types of affiliation. Affiliation is about control. That is the underlying goal of the affiliation rules, is to look for whether one firm has the power to control another firm, or if a third firm has the power to control both. And this control can be positive or negative, and we'll talk more about negative control a little bit later. And it doesn't matter if that control is exercised as long as the power to control exists. What we've listed here in the table at the bottom of this slide are the different types of affiliation found in the SBA's affiliation rules. And the citation we've given you here to 13 CFR 121-103, that's the SBA's affiliation rules. And you have these various types of affiliation then that can arise under the SBA's rules. And we're going to drill down on each of these as we move through the presentation. Just to give you a little more basics about affiliation, an affiliate can be any business, whether it's for-profit or non-profit, domestic or foreign. Affiliation can be an ongoing issue based on the nature of the relationship between two companies. Affiliation can also arise on a contract-specific basis, with the way that you put together your arrangement with another company for a particular project. Affiliation is determined at a specific point in time. So what we mean by that is, if the SBA comes in to judge your size status, generally they're going to do that as of a particular date, such as when you submitted your proposal with price. So they're going to be looking at whether affiliation existed as of that particular date. And they're not going to necessarily be swayed or look at the nature of the relationship prior or certainly after that point in time. So it's at a particular point in time. And we note here also that there are exceptions to the affiliation rules for certain firms owned and controlled by Indian tribes and Alaskan Native corporations, Native Hawaiian organizations, and community development corporations. And that's just something for you to note. It's not a focus of this presentation, but there are exceptions for those types of firms. And with that, I'm going to turn it over to Kimi.
One type of affiliation found under the SBA regulations is affiliation based on stock ownership. There are three ways control or affiliation can arise based on stock ownership. First, where an individual or entity owns, controls, or has the power to control 50% or more of another firm's voting stock, or a block of stock that is large when compared to other outstanding blocks of shares. Second, where individuals or entities own, control, or have the power to control roughly equal minority holdings of voting stock, and the aggregate of the minority holdings is larger than any other stock holding. This scenario creates a rebuttable presumption that each person holding a minority interest has the power to control the firm. Third, if a firm's voting stock is widely held and no single block of stock is large, the board of directors and CEO or president will be deemed to have the power to control the concern in the absence of evidence to the contrary. A second type of affiliation is affiliation based on stock options, convertible securities, and agreements to merge. Under the regulations, the SBA considers stock options, convertible securities, and agreements to merge, including agreements in principle, to have a present effect on the power to control a concern. The SBA, in other words, treats such arrangements as though the rights granted have already been exercised. This is known as the present effect rule. The SBA, however, will not give present effect when the agreement is merely to open or continue negotiations towards the possibility of a merger or a sale at a later date, or where there are conditions precedent that are incapable of fulfillment, unenforceable, or extremely remote. A third type of affiliation is affiliation based on common management. Affiliation may arise where one or more officers, directors, managing members, or partners who control the board of directors and/or management of one concern also control the board of directors or management of one or more other concerns.
Thanks, Kimi. The next type of affiliation I'm going to talk about is affiliation based on identity of interest. This is one of the more common types of affiliation that we see in cases where either a protest has been filed or a company is coming to us looking to fracture a relationship or understand how they might be able to avoid an affiliation. And the SBA's rule on identity of interest says that two or more firms that have identical or substantially identical business or economic interests may be affiliated under this rule. The identity of interest can arise based on family relationships, and we'll get more into that later. Individuals or firms that have common investments may be said to have an identity of interest, and firms that are economically dependent based on contractual or other financial relationships may be found to have an identity of interest. In general, this is a rebuttable presumption of affiliation, so you can demonstrate that in fact you do not have an identity of interest with another company if you can show that the interests that are thought to be identical are in fact separate. And the buzzword here is fracture, to demonstrate a fracture in the relationship between the companies. A little bit more on this next slide just to drill down on familial identity of interest. Again, this is a rebuttable presumption that close family members have an identity of interest. So we're talking about father, daughter, husband, wife. And what we mean here is that if the father and the daughter, or the example given in the next bullet is husband and wife, they each have interests in separate firms. So the rule will say that those two firms have an identity of interest, a rebuttable presumption of affiliation based on the family relationship in the ownership of both companies. However, the family members have to control their respective companies, and that's what this hypothetical drills down on. If one of the family members does not have the ability to control his or her company, there will not be affiliation based solely on the familial identity of interest. Now, there could be affiliation for other reasons, but for familial identity of interest to arise, the family members have to control their respective firms. And again, because it's a rebuttable presumption, well, how can you rebut it? And the rule and the case law that has interpreted the rule talks about showing either that the family members are estranged or that there is, and here comes that buzzword again, a clear fracture in the businesses. So again, the family relationship alone generally will not create an affiliation. Another type of identity of interest to drill down on in the next slide is the economic dependence. And this can arise when one firm provides critical financial assistance to another firm, such as loans or financial guarantees. It can also arise based on contracting. And what I mean by that is that if one firm is in the subcontractor position and is dependent on receiving subcontracts from another company for a significant percentage of its revenue, then the SBA may find that subcontractor is economically dependent on the prime, because if the prime turned off the flow of work, that subcontractor would be in serious trouble because so much of its revenue depends on getting work from that company. Now, what we've mentioned here, SBA case law that talks about 70% or more as a matter of law is economic dependence. If you're getting depending on someone for 70% or more of your revenue when you're in the subcontractor position. And we'll drill down a little bit on that when we get to the tips and real-world scenario section, but you should just know as a starting point there is this 70% out there.
Another type of affiliation is affiliation based on the newly organized concern rule. This is designed to prevent firms from circumventing the size standards by creating a spin-off. Affiliation arises when all of the four following factors are met. Number 1, former officers, directors, principal stockholders, managing members, or key employees of one concern organize a new firm. Note that a key employee is someone in a position of critical influence or substantive control over a firm's operations or management. Number 2, the new concern is in the same or related industry. Number 3, the persons who organize the new concern serve as the new concern's officers, directors, principal stockholders, managing members, or key employees. And number 4, the new concern or one concern is furnishing or will furnish the new concern with contracts, financial or technical assistance, indemnification on bid or performance bonds, whether for a fee or otherwise. Affiliation will also be found when you have joint ventures. Joint venture partners are generally affiliated for a contract, so a JV will be considered a small business if the combined size of the JV partners meets the size standard for the contract. JV partners can also be deemed affiliated for all purposes if the JV is awarded more than 3 contracts in a 2-year period. There are exceptions to joint venture affiliation, such as when each JV partner is small under the applicable size standard, and either 1, the procurement is bundled or consolidated, or 2, the procurement exceeds 1/2 the size standard, or $10 million, depending on the nature of the size standard. Another exception from affiliation for joint ventures are JVs between an 8A protege and an SBA-approved mentor. In 2014, the SBA is expected to propose rules to provide similar type exceptions for JVs involving SDVOSBs, HubZone, WOSBs, and small business proteges. Another type of affiliation related to joint ventures is affiliation based on the ostensible subcontractor rule. A contractor and its ostensible subcontractor are treated as a joint venture, and therefore they are affiliated. An ostensible subcontractor is a subcontractor that performs primary and vital requirements of a contract, or upon which the prime contractor is unusually reliant. Ostensible subcontractor affiliation is a contract-specific form of affiliation, and whether ostensible subcontractor affiliation exists is based on the unique facts and circumstances of the solicitation in question and the parties' approach to the project, as will be reflected in their teaming agreement, subcontract, and proposal. Another type of affiliation is that based on franchise and license agreements. Generally, a franchisee or licensee will not be affiliated with the franchisor or licensor based on customary restraints that are imposed under the franchise or license agreement. Permissible restraints include standardized quality, advertising, accounting format, and other similar type provisions. The franchise or license agreement must ensure that the franchisee or licensee has the right to profit from its efforts and bears the risk of loss commensurate with its ownership. Affiliation can arise, however, for other reasons such as common ownership, common management, or excessive restrictions on the sale of the franchise interest. It is important, therefore, to be wary of rights of first refusal or automatic buyback provisions of the franchise interests.
And I'll just add one point about the franchise and license agreements. There's something called the franchise registry. And if you're a prospective franchisee or licensee, you may want to check the franchise registry to see if your franchisor has an agreement on the franchise registry. If an agreement is listed on the franchise registry, it may have undergone a vetting process to determine that it is consistent with SBA's affiliation rules. So, one last element under the SBA's affiliation rule that they can use to find affiliation is the totality of the circumstances. And this is a broad and sort of sweeping rule, and I think it's intentionally designed that way so that the SBA can find affiliation in a circumstance where there may not be one particular rule that applies, the ones that Kimi and I just finished talking about, but the whole picture is one of affiliation. It is so suggestive of reliance. That's the emphasized words here, that they're going to find affiliation. Now, OHA, the SBA Office of Hearings and Appeals, when they look at these affiliation decisions the SBA makes, they have said that they prefer for the SBA to first analyze and look to find affiliation under the other more specific rules that we've just finished talking about. But this catch-all rule is out there. I've never seen a size ruling based only on the totality of the circumstances. In my experience, it becomes sort of the cherry on top of the sundae, if you will. When they've found affiliation in other areas, they will add on, and also the totality of the circumstances reflects affiliation. But I don't think I've ever personally seen it as the sole basis for affiliation. So with that, we've finished running through the different types of affiliation under 13 CFR 121-103, the SBA's affiliation rules. So now we want to drill down on some real-world examples and situations and give you some practical tips on how to address similar situations that you might face and to either mitigate or eliminate possible affiliations. And we've led off with ostensible subcontractor here because that is the most common form of size protest that we see these days. By far the most popular size protest ground. And when you are going after a project with a subcontractor, and particularly if your subcontractor is the incumbent, or if you're the subcontractor and you're the incumbent and you've found a small business to partner with, you should be anticipating or expecting an ostensible subcontractor protest at the outset of putting the relationship together, so that you can put the relationship together in a way that best insulates you from an ostensible subcontractor protest. And the way to do that, the starting point for that, is your teaming agreement. Your teaming agreement needs to make clear that the prime contractor is in charge of the project and is performing the key functions. And to go back to what the rule says, they're looking at primary and vital requirements. They want to see who's doing the primary and vital requirements. And I've seen a few questions pop up already on, well, what are the primary and vital requirements? How do we know what they are? The RFP is your starting point for the primary and vital requirements. The RFP may not come right out and say, these are the primary and vital requirements, but you should, in most cases, be able to piece it together from the RFP. What you'll want to do is you'll look at the CLINs, and the anticipated value of the different aspects of the work. And it's not necessarily always tied to the most valuable work is the primary and vital work, but that's a good indication of what might be the most important work on the project. What do the evaluation criteria say? If the agency's really focused on something in particular in the evaluation criteria, or the past performance that parties have to bring to the table, it may be that those things are the primary and vital purposes of the project. That's what the agency wants. That's what they're looking for you to bring to the table. Clearly, project management, the overall running of the project is almost always, I think, going to be part of the primary and vital requirements. So it's something you're going to piece together from the RFP. The agency itself may tell you either in, if not right in the RFP, maybe in questions and answers, maybe historical data about the incumbent project. The NAICS code assigned to the contract will also give you an indication of what they consider to be the key aspects of the project is if you go to the U.S. Census Bureau has definitions for all the NAICS codes, and that definition, it's not dispositive. The NAICS code isn't dispositive of what the primary and vital requirements are. And I've just been handling a case recently on that exact issue. But it is important that what is the NAICS code and what type of work generally falls under that NAICS code. These will all give you clues as to what the primary and vital requirements are. And then in your teaming agreement, you want to be as discrete as possible in the functions you assign to your subcontractor. Where we've seen people get into trouble is where the subcontract says, basically we're all going to do the project together and do a great job for the client. And when the SBA comes in, they can't tell, well, that's great, but what is the subcontractor doing and what are you doing? And specifically, and where did you draw the lines on this is our work, this is their work? And if you just simply say, well, we're going to do 51%, they're going to do 49%, well, what's in that 51%? Because just simply doing 51%, I think this is an important point, just simply doing 51% of the work does not automatically mean you are doing the primary and vital requirements on the contract. The SBA will look at what does that 51% entail. Did you put most of the administrative and more ministerial functions in that 51% and the really critical, technical, or more profitable projects are within the subcontractor scope of work? Or maybe it's not clear and the SBA can't tell, and therefore they have to conclude, well, we don't know that the is doing primary and vital requirements. And by the time you get a protest on this issue, it's too late to change your teaming agreement. So that's why we say from the very start of the relationship, and the teaming agreement generally is that start of the relationship, you want to be mindful of the types of things that somebody like me would need to draw upon to defend an ostensible subcontractor protest, and I would like a teaming agreement that clearly gives the prime contractor the primary and vital requirements, that assigns discrete functions to the subcontractor. And along those lines, the next slide talks about what the SBA generally will look at in an ostensible subcontractor case. They used to look at, do the so-called 7 factors test. OHA told them to stop doing that a few years ago, and so the SBA will look now at the totality of the circumstances. I mean, frankly, whether you call it a 7 factors test or totality of the circumstances, it's really the same types of things. What happened with the proposal process, who did what there, is the subcontractor the incumbent? If your subcontractor is the incumbent, it doesn't mean you're automatically affiliated, but it does heighten the concern for ostensible subcontractor affiliation. So you need to be even more mindful of these issues if the subcontractor is the incumbent. Again, who's doing the more complex and costly contract functions, and what are they? Have you assigned discrete tasks? And these are the kinds of things that you're going to set up in your teaming agreement, maybe a subcontract, in your proposal. All of those things ideally will line up together to help you defend arguments that you're not, as the prime contractor, doing primary and vital requirements. So they're going to look at your proposal. They're going to look at your teaming agreement. If you have a subcontract, they're going to look at that. They're going to ask for tax returns and financial statements, and they're going to ask you to fill out an SBA Form 355 where you disclose any other relationship, prior work, assistance on the bid, etc. So they're going to look at the whole history and nature of the relationship between the two companies when they come in and do an ostensible subcontractor review. I put this last bullet on here just to point out, because it's a common point of confusion. If you're bidding as a joint venture, so you've actually formed a joint venture, ostensible subcontractor does not apply. The ostensible subcontractor rule is saying, and Kimi mentioned this before, this rule is part of the joint venture affiliation rules. So what the rule is essentially saying is, you may not have formed a joint venture, but we're going to treat you as if you formed a joint venture given how you set this up. So if you've actually formed a joint venture, there is no need to treat you as a joint venture. You already are a joint venture. So just keep that in mind. I've probably covered a lot of this already on the next slide, but I think it's worth drilling down on who prepared the proposal a little bit more, because we've seen this become more of an issue recently. Several cases we've been handling where there's been a lot of questions about who did the proposal, and you know, it's a double-edged sword here, because on the one hand, you can certainly rely on a subcontractor to provide assistance in preparing the proposal, particularly when the subcontractor is the incumbent and really knows the secret formula to win the work. But if you go too far, too much control or influence can be a factor in finding affiliation. There was a relatively recent case where the SBA Office of Hearings and Appeals said that a subcontractor that had done the, quote, heavy lifting in preparing the proposal was not affiliated under the ostensible subcontractor rule. But OHA, they didn't excuse it. They said it was a factor in finding ostensible subcontractor affiliation. So they didn't overlook it entirely, but they weighed the totality of the circumstances. And in that particular case, they found that there were other factors that more strongly weighed against affiliation, even though the subcontractor was very involved in preparing the proposal. Now, the type of circumstance where that might be more permissible is mentioned in the next set of bullets, with, like, for example, an LPTA, a lowest price technically acceptable procurement. In that type of procurement, the technical proposal and the past performance proposal, you know, there's a low bar to clear, and you know, you're not really getting a bump in terms of your evaluation from the technical and past performance proposals really setting themselves apart. So there's a better argument there that a subcontractor being more involved in that type of a proposal and that type of a procurement should be less of a factor in affiliation, whereas if you've got a very technical-centric evaluation and RFP, and the subcontractor really, you know, brought everything to the table in terms of putting that technical solution together, you're going to have, I think, more of an issue from affiliation in that type of procurement. Who's providing the key personnel? This is another one I wanted to spend just another minute on regarding ostensible subcontractor affiliation, because this has come up a lot recently too. Probably most folks participating are familiar with the executive order from a few years ago and the regulations that have been implemented since then that require contractors to give a right of first refusal to certain incumbent personnel. So as a result of that, OHA for a few years now has not been finding hiring incumbent personnel is a factor in ostensible subcontractor affiliation. But there's a caveat to that. Some firms have gotten into trouble because they've done wholesale personnel transfers where they basically, the prime had no people of its own, and the including the management. And I think the management is the key takeaway there, that the subcontractor basically gave all of its people, say, you know, on day one of the contract, you'll go over and you'll become employees of this prime small business prime contractor. And while giving a first right of refusal to certain incumbent personnel is required, you're not required to hire management personnel. And so if you're going to transfer entirely the workforce from the subcontractor to the prime, including all of the key management, this executive order is not likely to help you avoid affiliation. So you need to be mindful of what are the required labor positions on the contract, and how many of those positions is the prime contractor able to fill without having to take people from the subcontractor. Now I'm going to turn it over to Kimi. She's going to run through some tips related to corporate issues.
So the first tip we wanted to talk about in the corporate area is the use of the former affiliate rule in corporate restructuring. Importantly, the SBA's rules do not say once affiliated, always affiliated. In other words, affiliations can change or lessen over time. The former affiliate rule allows you to back out the revenues or employees, depending on the type of size standard, of a former affiliate from your revenues and employees for the entire time period used to measure your size. This can be retroactive, and it can be used effectively in corporate restructuring in order to sell a subsidiary or sister entity and reestablish the former parent or subsidiary as a small business.
So let's talk about this for a minute, what we mean by retroactive, because again, to go back to a point we made very early on, the SBA is going to measure your size at a particular point in time. And at that point in time, they're going to look at, for example, your 3 most recently completed fiscal years. So let's say you have an affiliate during those 3 fiscal years. Let's say it's a subsidiary, a wholly owned subsidiary. And you're tracking it so that you can easily tell what portion of your revenue is attributable to that wholly owned subsidiary. If you can successfully fracture the subsidiary, meaning you sell it to an independent party, let's say, if you can fracture that subsidiary by the relevant point in time for the SBA to measure your size, then you can retroactively take that subsidiary's revenues off your books, so to speak, for the 3 most recently completed fiscal years. So that's what we mean by establishing yourself as small. Maybe you used to be small, but you've grown to be too large. And a strategy that people will use sometimes is they'll take a division and put it into a subsidiary and then sell off the subsidiary. And when you do that fracture, the former affiliates' revenues that used to be part of your revenues, you can take them out for purposes of determining your size, retroactive. So it's very beneficial if you can do the fracture by the point in time that the SBA is going to measure your size.
Another tip in the corporate area is to be careful with your letters of intent. The SBA will give present effect to a letter of intent that is too definite. Some tips, therefore, to lessen the chance of affiliation based on your LOI include carefully describe due diligence that has been completed and is yet to be done. Another one is to emphasize the non-binding nature of the letter. Be careful with your use of words and change words that indicate that the transaction is definite. Also consider when the deal may be finalized and what set-aside opportunities may be on the horizon. You may even want to ask yourself if you even need a letter of intent.
Yeah, and I had a case a few years ago on this present effect rule with letters of intent, so it's near and dear to my heart. And it's a difficult rule to get your mind around, I think, because the rule says an agreement in principle gets present effect, whereas an agreement to negotiate doesn't. So what's the difference between an agreement in principle versus an agreement to negotiate? That's not necessarily clear from the regulations, and it can be interpreted a little differently on a case-by-case basis. Where you get into trouble, where you can get into trouble with this, is when you make the deal seem too definite in your letters of intent. So that's why we're saying, look at the language. How is this letter put together? Does it seem like it's all over but the shouting? I mean, you've already done the dance for a while. You've looked under the hood. Everybody's pretty comfortable. You've got a price pretty well zeroed in on. And there might be a few things you've got to do, still, and yes, it's a non-binding letter of intent, and you stamp it, in 20-point font, non-binding. But if the message that really comes across from this letter is we've pretty much reached an agreement and we just need to do a few things to cross the T's and finalize it, the SBA may very well treat that transaction, the contemplated transaction, as if it already occurred. And that can have a big ramification on any proposals you might be about to submit, even though you haven't closed the deal yet. And something else interesting I want to note about this rule, I said early on that for the most part, the SBA judges your size based only on the circumstances that exist as of that relevant date. This is one case where that's not entirely true, because the SBA can look at what happens after the relevant date in determining whether to give present effect to a letter of intent that existed prior to the relevant date. And what I mean by that is, let's say you have a letter of intent that you sign in September, and the proposal goes in October. So your relevant date for measuring size is October, and you close the deal in November. The SBA, even though the deal closed after the relevant date, the SBA could look at that set of circumstances and say the fact that the deal closed so closely in time to the letter of intent and the proposal is a factor in us giving present effect to that letter of intent. So they'll essentially use a future event to prove that the letter of intent was fairly definitive enough to give it present effect. So just be mindful of that when you're doing these types of letters, and think about what proposal opportunities you may have upcoming and whether you can even consider possibly delaying or just not doing the letter of intent to avoid the risk.
Another tip is to check your corporate records or documents for negative control. This negative control may be lurking in your quorum, voting, transfer, and other provisions of your governing documents, like your bylaws, your operating agreement for LLCs, or your shareholders agreement. Negative control may arise through supermajority provisions that require a minority owner's approval for day-to-day operations. For example, hiring and firing of executive officers, setting executive compensation, the power to approve a board member, and veto power that gives control over board committees. It is important to note, however, negative control would be unlikely to arise from supermajority requirements for extraordinary actions, such as the addition of new owners or changing the size of your board. Some tips with respect to rebutting a finding of control based on stock ownership. As we said earlier, if an individual or entity owns, controls, or has the power to control 50% or more of another concern, this is deemed to be control, and affiliation will be found. These facts create a non-rebuttable presumption. If no single owner holds 50% of the stock, the SBA will presume that each owner controls the company, but in this situation, you may be able to demonstrate otherwise. This will depend on the ownership percentages and other factors, such as are any of the owners passive investors, or are they all voting members of the board and officers involved with day-to-day operations. To rebut a presumption of control, you would need to clearly demonstrate through your corporate documents and actual operations that certain owners do not participate and have no ability to control the company. Another tip in the corporate area is to do not put all of your eggs in one basket. Affiliation based on economic dependence, as Jonathan mentioned earlier, arises when you receive 70% or more of your revenue from another company, and can also occur at lesser percentages depending on other factors. This applies when you are in a position of a subcontractor, but not when you are the prime contractor. And as Jonathan talked about, you can fracture economic dependence if you show a downward trend in the percentage of revenue by the time of the relevant date for measuring your size. It's also important to note recently that SBA's Office of Hearing and Appeals has stated that the revenue test must be carefully applied so it does not unfairly penalize startups or new companies. In other words, a firm should not be found economically dependent based upon its first contract.
And let me just make two add-on points there. I saw a question came in about somebody, their first couple contracts, and is that enough to create affiliation? Are you affiliated with the first company that you get your a contract with? And Kimi just addressed that. So the answer should be no. There may be other circumstances that could heighten affiliation in a particular circumstance, but we've seen from this standpoint, for the standpoint of startups, we've seen some helpful decisions out of the Office of Hearings and Appeals recently that indicate we shouldn't be penalizing these startups when they get their first contract and find them affiliated with that company. Because then, of course, everybody would be affiliated with the first company they ever get a contract with. The other point of clarification I wanted to make on this slide is the sub-bullet that says that the economic dependence applies when you're in the position of a subcontractor. I want to make sure it's clear that we're talking about the 70% of your revenue issue. It's when you're in the subcontractor position that is an issue, because the SBA will say when you're the prime contractor, you can control whether to award a subcontract or not. So you're not going to be economically dependent if you've awarded as a prime contractor 70% or more of work to one firm. It's going to be when you're in the subcontractor position, economically dependent on a significant percentage of your revenue from contracts that somebody else is awarding to you. Now, that doesn't mean that as a prime contractor you can never have economic dependence on a subcontractor, or that affiliation might not arise through other means like identity of interest. I mean, certainly if you're doing a significant amount of your contracting with one company, even as the prime, you might have an identity of interest issue start to arise. But just wanted to make clear when we're talking about the 70%, we're talking about the subcontract position. All right, so let's talk about the family relationship issue next. Give you some tips or answer some questions about what happens in this situation when you have a family member who owns a business. First, you ask yourself, how close is the family member? Is it, and I mean in terms of relationship, is it father, son, husband, wife, third cousin? It's not going to be an issue, but a close family relationship like father, son, husband, wife, brother, sister, that's going to create the rebuttable presumption of affiliation. So then you have to ask yourself, well, does that family member control his or her company? And this is what I talked about earlier. There has to be control by both family members in their respective companies. So if your close family member does control, there's a rebuttable presumption of affiliation. Go to the next bullet. If the answer is no, that family member doesn't control his or her company, then at least you can cross off the list affiliation based on the family relationship. There might be affiliation for other reasons, but it shouldn't arise based solely on the family relationship. So in terms of rebutting the presumption, so we get to the last bullet because we do have a close family member that controls his or her company. There's two things that we can do to rebut this. And the first one here is obviously tongue-in-cheek, stop inviting them to Thanksgiving. I mean, what we mean here is that there's estrangement between the family members. This isn't a strategy that you can employ or that we would recommend employing. It's just if the facts support the fact that the family members are estranged for whatever reason, then you can rebut affiliation by pointing that out to the SBA. And in fact, there was just a very recent OHA decision I was reading where that exact fact pattern played out, and OHA upheld that there was no affiliation because the owner demonstrated that she was estranged from her family member. What you can employ more as a strategy is the second sub-bullet here, keeping the businesses separate. You can take steps to fracture the relationship between the companies to show that, yes, my family member owns her own company, but we're in totally different lines of business. She's in Maine, I'm in Colorado. We don't do any work together. We don't have any contracts. We don't share personnel. Anything you can show along those lines will help to demonstrate that there's a fracture sufficient to rebut that presumption of affiliation. Okay, next one. This slide is geared towards the newly organized concern rule. So what do we do if this is an issue? This rule is designed, I think, to catch a situation that people come to us and ask a lot. Let's say my company is approaching the size standard, or I just went over my size standard, so I can't go after small business work anymore. Can I just form a new company and have, Johnny, my key guy, run it for me, and then that company can go off and be a small business because it's brand new? And the answer is, well, maybe not, because of this newly organized concern rule. So this is the way the SBA can protect against that scenario where, one company just continually spins off new small businesses. It is called the newly organized concern rule for a reason, so keep that in mind. We've seen some cases where there's been questions about whether a firm is affiliated under the newly organized concern rule, but it was formed like 6 years ago, and that's too long to still be a newly organized concern. The rule doesn't say specifically what period of time is enough. I've always thought that 3 years is a good rule of thumb, and I think there's some case law to back that up, that if it's been in existence less than 3 years, you're more in the realm of a newly organized concern than if it's been in existence for more than 3 years. As Kimi mentioned when she talked about the elements of the newly organized concern rule, you have to hit all 4 of them to be affiliated. So you can look to rebut this affiliation by knocking out any one of the 4 elements of the rule. And one of the ways you can do that is to demonstrate you weren't an owner or an officer or a key employee, or if there's no ongoing assistance or relationship with the other company. So those are strategies you can employ. You can make those decisions to fracture that affiliation. So we're just going to conclude, and we'll turn over in the time we have left to try to answer a few questions. But just to sum things up here, tips to avoid affiliation, I guess your key takeaways. Understanding the various ways affiliation can occur. A lot of folks find themselves in an affiliation they didn't even realize was a problem until it's too late to address the relationship. So know up front the ways you can be affiliated. Be proactive in assessing the potential for affiliation prior to corporate transactions. That's near and dear to Kimi's heart. When you're doing letters of intent and due diligence and other steps for a possible transaction, make sure you've considered the ramifications for affiliation. And in your corporate documents, watch out for provisions that give a minority shareholder too much control. Don't keep all your eggs in one basket, like Kimi said. Be diversified in your teaming partners and sources of revenue. At least consider the potential of affiliation with family members. And this last point, make sure your website and marketing materials don't create a misimpression of affiliation. I would say it's a significant percentage, like almost all protests that we see where one of our clients is being challenged for their size status, the protester has included some printout of a website, whether it's the client's website itself, whether it's a profile from Dun & Bradstreet or Corporate Wiki or any of the other myriad things that you can find out there on the web about a company. And they use that information to support their allegation of affiliation. Now, the good news is that the SBA says they're going to go with what you tell them under oath as compared to things people find on the internet. So if you can rebut those websites with your information in response to the protest, your information should prevail. But a lot of people unwittingly walk themselves into protest because they've left outdated information on their website, or they describe a relationship with another company in such terms that it gives an impression that the companies are working really closely together. There's just things you can do to be more careful and make sure your information is up to date on your website and your marketing materials, etc. And with that, let's scroll through your questions here. I know Kimi is looking at them, and I'll do the same. And it looks like we have somewhere in the neighborhood of 5 to 10 minutes left, so we'll answer as many as we can, sort of reading on the fly here. Please fire them all in, because we will respond to each of you by email after the presentation if we don't get to answer your question today. Somebody asked if our firm will do an audit to assess affiliation. We did not plant that question, but yes, we will do. This is a large part of our practice is to come in to do an assessment. Some clients like to do it do an annual checkup, so to speak. They'll tell us about any changes in their corporate or management structure, and we can assess whether there's any impact on affiliation and size status for the upcoming year. Other firms do it just because maybe something has happened that has caused them to be concerned about it. And something else I'll add along those lines, with this new presumed loss rule I mentioned, one of the mitigating factors in the presumed loss rule that would mitigate against liability for the contractor is if you have internal controls and procedures in place. So as a result of this rule, we've recommended to everybody, have policies and procedures on how you do your size and status representations. There should be something in place for the company where you say, before we say we're small, on a proposal or on a subcontract, we do the following things. We check this, we check that, we escalate it up the chain of command. If there's a question or a concern, we'll go to outside counsel in certain instances if we need guidance. But that there are steps that you work through before you check that box when you submit your proposal, and that would help mitigate if later an agency comes in and questions whether that was an accurate representation. So putting together those types of policies and procedures is something that we can help with too. Somebody asked whether a revenue sharing agreement between two entities would constitute control. I think it's hard to answer that question to say that generally in all cases a particular type of agreement would create affiliation. I mean, some agreements are going to be more likely to create affiliation than others, and to me a revenue sharing agreement sounds sort of like a joint venture. And as Kimi mentioned, the rules say, with some exceptions, but the rule generally is that joint venture partners are affiliated. So I think you'd have to look at the specifics of the agreement. Does the agreement give one party the ability to control the other through the way that they're sharing the revenue? Somebody economically dependent on the other party in sharing that revenue. But the concept of sharing revenue off the bat to me sounds like it could be viewed as a joint venture, which would create affiliation. Again, we had a few more questions on whether the PowerPoints will be posted. We're going to send them out via email. To everybody who signed up, you're going to get an email, I think later today, with a link to the slides and the audio. And then in addition to that, they're going to be on the Resources tab of our website probably by tomorrow, along with all the other set-aside webinars that we mentioned. Somebody asked whether a passive investor from the same industry would maybe not be affiliated. And I think if you have to look at is it truly a passive investor? Is the person, how involved at all are they in the operation of the business? I will say that rule that you're talking about there in your question, that when there's multiple owners and nobody's at 50%, The rule does say you can rebut the presumption of control, but I haven't found a case where anybody successfully rebutted that presumption. So it says to me either it's not commonly used or it's difficult to do. But I think if it's truly a passive investor, no involvement in control, and you can demonstrate that through the corporate documents, I think you'd have a good argument that that's what the rule is talking about in rebutting control. It looks like we've hit our time limit here, and there are a number of questions that we didn't answer, so Kimi and I are going to get right to emailing each of you. I thank you all for participating and submitting your questions and for your time today, and if you have any other questions, please feel free to email Kimi or I. Our email addresses are right here on the slides, and check our website, PilieroMazza.com, for more information. Thank you very much.